Hello everyone, I'd like to take this opportunity to give an overview of the Ontario Human Rights Commission's policy on removing the Canadian experience barrier. But before I do that, I'll briefly describe the process that the Ontario Human Rights Commission undertook in developing this policy. In 2012, we began our work in this area by conducting interdisciplinary research. This included reviewing academic resources, as well as the case law that has dealt with issues relating to Canadian experience requirements. At the same time, we conducted an extensive public survey on requirements for Canadian experience in the employment sector. We also consulted directly with a range of organizations and individuals, including agencies serving newcomers, employers, government, and regulatory bodies. This background work showed us that newcomers face Canadian experience requirements from employers throughout the job search process. Feedback from our public survey showed that while some employers continue to ask for Canadian experience in their job ads, it appears to be more common for employers to ask about Canadian experience in more subtle ways, for example, through in-person interviews or through recruitment agencies. Organizations serving newcomers told the Ontario Human Rights Commission that in some cases, employers may disregard a resume that lacks evidence of Canadian experience, without the job applicant ever knowing the reason why he or she was never contacted for the position. Employers may also form conclusions about an applicant's lack of Canadian experience based on factors such as an unfamiliar resume or cover letter format, references in a resume to foreign work experience or foreign educational credentials, written communication style, a non-English sounding name, etc. When facing a requirement for Canadian experience, newcomers are in a very difficult position. They can't get a job without Canadian experience, and they can't get Canadian experience without a job. Many newcomers turn to unpaid or low-skill, low-paid work outside of their field of expertise to meet this requirement for Canadian experience. For example, one survey respondent wrote, "The main reason that they cited in support of their decision not to hire me is lack of Canadian experience. I have all the qualifications and over 12 years of experience in a multicultural and fast-paced work environment, and I feel that I have good communication skills too. I have even offered to work without wages for a few weeks so that they can judge me and my work. I have started getting frustrated and am planning to go back. They say they need skilled workers in Canada, but don't recognize your overseas experience." The Ontario Human Rights Commission learned that newcomers also face these obstacles when they try to get professional accreditation, as many regulatory bodies will not admit new members without prior work experience in Canada. The Commission's findings are consistent with those of Statistics Canada, which reported that between 1991 and 2006, quote, "the proportion of immigrants with a university degree in jobs with low educational requirements increased. This applied to clerks, truck drivers, salespersons, cashiers, and taxi drivers. Even after being in Canada for 15 years, immigrants with a university degree are still more likely than the native-born to be in low-skilled jobs." In a 2003 report, Statistics Canada identified a lack of Canadian experience as the most common barrier for newcomers looking for meaningful employment in Canada. This brings us specifically to the Ontario context. Many immigrants who have chosen Canada as their home have settled in Ontario. In Toronto, for example, almost half of the population, 47.3%, is foreign-born, the highest share for any major city in the developed world, including New York, Miami, and Sydney. Ontario's human rights legislation, known as the Ontario Human Rights Code, recognizes the inherent dignity and worth of every person and provides for equal rights and opportunities without discrimination. The Code aims to create a climate of understanding and mutual respect so that each person feels that they belong in the community and can contribute to it. Section 5 of the Code states that every person in Ontario has a right to be free from discrimination in employment based on specific grounds. People should not experience barriers to employment based on characteristics that are associated with any of these grounds. Section 6 of the Code states that every person in Ontario has a right to be free from discrimination with respect to membership in any trade or occupational association or self-governing profession. Therefore, regulatory bodies should not use membership or licensing criteria that could result in discrimination. Discrimination under the Code can be direct. For example, an employer may refuse to grant a job to someone because of prejudices related to where the person was born. But the Code also prohibits discrimination that results from requirements that may appear neutral, but which, in practice, have a negative effect on people identified by the Code. This is often called adverse effect or constructive discrimination. A job ad, hiring, or accreditation process that limits the opportunity to people with Canadian experience can have an adverse impact on recent immigrants. Most newcomers to Canada will not yet have Canadian work experience, even though they may have relevant international experience and may be qualified to do the job or to be professionally accredited. The Commission's policy makes it clear that a distinction based on where a person acquired their work experience may indirectly discriminate based on code grounds such as race, ancestry, color, place of origin, and ethnic origin. There is no common understanding of what skills employers or regulatory bodies are looking for when they ask for Canadian experience. This can be extremely frustrating for newcomers who may be qualified for a position or for professional accreditation, but who have not yet worked in Canada and are not given a chance to prove their qualifications. Many newcomers feel that the approach of many Canadian employers is arbitrary and needlessly penalizes them for their lack of Canadian experience. In some cases, requiring applicants to have Canadian experience may be disguised discrimination and a way to screen out newcomers from the hiring process. One respondent to the Commission survey stated, "I have worked all over Europe, and I know that there is no problem like European experience. I believe that Canadian experience is a self-invented barrier to stop immigrants with high education getting into highly paid, high-level jobs." The Commission's position is that a requirement for Canadian experience is discriminatory on its face, can only be used in limited circumstances. The onus will be on employers and regulatory bodies to show that a requirement for Canadian experience is a bona fide or legitimate requirement according to an established legal test. Under the Human Rights Code, when discrimination is found, the organization the claim is made against may try to defend itself by showing that the requirement that resulted in discrimination is bona fide or legitimate. In a legal decision known as the Mioran decision, the Supreme Court of Canada set out a three-part test to determine whether a requirement that results in discrimination can be justified as reasonable and bona fide. The organization must establish on a balance of probabilities that the requirement, 1, was adopted for a purpose or goal that is rationally connected to the function being performed, 2, was adopted in good faith in the belief that it is needed to fulfill the purpose or goal, and 3, is reasonably necessary to accomplish its purpose or goal because it's impossible to accommodate the claimant without undue hardship. What this means in practical terms is that it is up to an employer or regulatory body to show that a Canadian experience requirement is legitimate and reasonable. To do this, they must show that they have made the requirement as inclusive as possible and that they have taken steps to accommodate applicants covered by the Code. This would mean assessing people on an individual basis and would include considering non-Canadian experience and other qualifications. It's the Commission's view that an employer or a regulatory body will have a very difficult time showing that a requirement for Canadian experience is legitimate. Even where employers and regulatory bodies may be acting in good faith, an applicant's Canadian experience, or lack thereof, is not a reliable way to assess a person's skills or abilities. The policy includes a number of best practices that will help employers and regulatory bodies act in accordance with human rights principles. For example, employers should be clear about the specific qualifications they're seeking, rather than using catch-all terms like Canadian experience. So if the ability to communicate effectively is what is required, the employer should state this clearly and give applicants the opportunity to show this skill. Employers should separate job requirements that are legitimate from those that are simply nice-to-haves, and only require the level of proficiency that is necessary to do the job in question. Employers and regulatory bodies should list these competencies in the job description so that candidates can demonstrate how their skills match up to the requirements. Employment and accreditation decisions should not be made based on stereotypes about people or assumptions about the quality of work experience not gained in Canada. Employers and regulatory bodies should not treat a lack of work experience in Canada as equivalent to negative work experience or a bad employer reference, for example. The Commission's public survey revealed a strong tendency by employers to devalue foreign work experience. For example, one person said, "The first question is if I have Canadian experience, or in the worst of cases, if I have experience in Ontario. Then all my professional background goes to the garbage can. In some way, they force me to start again from zero, and I have to make all of my experience over here." The Commission's policy states that all prior work experience should be considered, regardless of where it was obtained. Where an applicant lacks Canadian experience for reasons related to a code ground, employers and regulatory bodies should look at other available information to make a reasonable and fair assessment. Applicants should be assessed on an individual basis rather than being screened out based on general rules, and they should be given an opportunity to demonstrate that they have the relevant skills and experience in a variety of ways. The essential question is whether the applicant is qualified to do the job. Decision-making related to hiring or accreditation should be as transparent as possible. Job ads, for example, should state clearly the specific skills and work experience that are required for each of the duties associated with the position, and job requirements must be related to the position. Job applicants should be given an opportunity to show their abilities during interviews and even in a simulated job setting. Employers who routinely refuse to hire people who are identified by specific code grounds may be motivated by negative attitudes, biases, and/or stereotypes. Employment decisions based on discriminatory stereotypes are a violation of the Ontario Human Rights Code. Employers should rely on objective and standardized criteria when choosing applicants to minimize the chances that discrimination will play a role in the selection process. Assessments based on whether a person would fit into the culture of a workplace, for example, are subjective and open the door for cultural biases and stereotypes to influence decision-making and may exclude people protected by the code. Where an employer receives multiple job applications, they should be prepared to show how they chose the successful applicant. Employers and regulatory bodies have a legal responsibility under the code to ensure that employment and accreditation practices don't result in discrimination. It's not acceptable from a human rights perspective to choose to remain unaware of the potential existence of discrimination or to ignore or fail to act to address human rights matters, whether or not a formal complaint has been made. Human rights decisions are full of findings of liability that are based on an organization's failure to appropriately address discrimination. The policy provides guidance to employers and regulatory bodies on how to fulfill their human rights responsibilities. Employment and accreditation requirements should be clear, reasonable, genuine, and directly related to performing the job or receiving professional accreditation. Canadian experience requirements will contravene the code where an employer or regulatory body cannot show that they are bona fide or legitimate in accordance with the established legal test. Employers and regulatory bodies that do not comply with the policy on removing the Canadian experience barrier may be vulnerable to having costly human rights claims filed against them. Building a diverse workforce with employees from different backgrounds makes good business sense. Canada as a nation benefits from the contributions of immigrants, and it needs these contributions to ensure its future economic growth and competitiveness.